Can you all hear and see us?
Yes.
I think if everybody's on mute, they can not probably tell us that. So hello, everybody.
Very true. Thank you very much all for joining us this afternoon. We hope it will be an interesting lunch hour for you. We appreciate it's lunch and you may be at home. By all means, keep your cameras off if you wish, or keep yourself on mute in case you have any parcels coming or you want to get some lunch. So absolutely no issue on our end. So I'm going to speak first. I'm Richard Harrington, and then Julia Nelson will talk about the Gohill case. My topic is going to be on personal injury, case law, preserving damages, and approaches to settlement. So just a bit about me before we start. I've been a tenant in Chambers since October 24. So I've almost been a practicing barrister for 2 years now. I specialise in financial remedy proceedings, private law children, public law children, TOLATA, the whole lot. So that's me. I can see there's a hand up from Asia.
Asia, can you hear us now? Maybe it might be your sound, your end. Can everybody else hear?
We see Gemma
Yes, we can.
nodding.
Okay.
Yes.
Might be your end then, Asia. Okay, go ahead,
Brilliant.
Richard.
Thank you. There is a detailed handout, which in many respects to me means you don't have to take notes unless a particular point really interests you. The handout may have already been sent to you. If it hasn't, it will make its way to you after today's training. Okay. Now, in terms of personal injury awards in financial remedy proceedings, they are an interesting issue and topic. They always add another level of complexity to a case. And I wouldn't say that they are rare, but they're certainly not as common as the standard issue that you may experience during a financial remedy case. The problem that we have as lawyers is, one, we know that personal injury awards and how they're treated are very fact specific to a case, and every case will be treated differently. But then the other issue we have is how much discretion the court has when interpreting and applying the Section 25 factors. And it therefore makes our job incredibly difficult when advising clients, because we have to provide a number of caveats to any advice we give people about personal injury awards. So that's a difficulty that we have. And the one point I'd make very, very early on is that early advice is imperative. Whether that be you're working with in a team and you see someone more senior to look over the case, discuss the case, or whether it is bringing in counsel early just for their thoughts and views on how the PI award should be treated, and especially before any offers are made. The difficulty as well with Section 25 is that the court will have to look at the source of especially of damages in terms of pain and suffering. I can just hear someone coughing. If you're not on mute, would you mind put yourself on mute? Thank you. The difficulty is in terms of the source of damages alongside needs. And as we know, needs are always trump, and that can always be a difficulty that we have. It may be surprising to a lot of you when we go through this lunch hour, or half an hour for me, that you'll be surprised that there is limited case law actually on this issue, largely because the law has been pretty settled in relation to a case of Wagstaff, but we'll come on to that slightly later on. But what is clear is that personal injury awards are not automatically ring-fenced. It depends on needs. It depends on the sums involved, the source of damages, why they were paid, how they've been mingled, and whether they have been matrimonialized. These are all factors that we will consider in due course. So if it's not obvious, it should be from my introduction that damages awarded in PI are an available resource when we consider Section 25 factors. The leading case is still Wagstaff, which is a 1992 authority. There are some other cases which predate Wagstaff, but having said that, the law has been fairly settled since then, and I've therefore gone about it that I go from Wagstaff onwards, as this is the starting point, and this is still the leading authority. So in this case, it was an 8-year marriage. 2 years prior to separation, there was a road traffic accident. And 5 years after they separated, the husband received £418,000. At first instance, the wife kept the family home, and the court ordered that the husband was to provide the wife a £32,000 lump sum. The judge recognised that this was an award from personal injury damages. The husband appealed successfully on the basis that there should be very little to no lump sum made, but then the wife appealed, and that went to the Court of Appeal. But this time, the wife was seeking to receive more than the £32,000 the judge at first instance awarded her. Lady Justice Butler-Sloss made clear that a personal injury award is a resource that can be factored into Section 25, as I've already said. And on the slide, I have included a quote from Lady Justice Butler-Sloss. But to break that down, the key points are the source of the capital, how the source of the capital became available, and its value is highly relevant when considering Section 25. Personal injury awards are not protected against an application made by another spouse. The smaller the sum awarded, and if awarded due to pain and suffering, it is less likely to be paid to the other spouse. The fact that it has come from compensation through damages, depending on the circumstances, that could, in some cases, especially in terms of sharing, exclude those damages being paid or shared to the other spouse. Each case must be considered on its own facts. A more highly relevant consideration that does not limit the discretion of the court. And that last point is difficult for us because, again, it goes back to how discretionary each judge will apply the law on PI. It's not on the slide, but Lord Donaldson also made the point that it has been the money has been brought in to the marriage, not via the fruits of the marriage, but by a loss of amenity often. And that could be a relevant factor when the court considers financial needs. So in this case, the Court of Appeal actually said that the sum of £32,000 was a fair settlement in the grand scheme of things. So they agree with the judge at first instance. So this is the leading authority. There are other cases which I have included on the slide, which I'll go through now. I don't have time to go through all of them in detail, given we only have 30 minutes today, but there is a detailed handout. So I will go through them as quickly as I possibly can. The first case is C&C. In this case, there was a marriage. There was a child of the marriage. The husband, after a road traffic accident, I believe, was awarded £5 million. He had significant needs. He had permanent brain damage. And he was awarded this 2 years after the decree nihil nihil was pronounced. He had to move to Cyprus, and he was being cared for by his parents. Now, the wife sought...
Sorry, Jen, I've just got this webinar in the background. You can keep going.
Could you...
I haven't got any. Right, thank you for trying.
Could we just... Louise, could we just put yourself on mute, please? That's all right. Thank you. Now, the wife only sought, despite the award of £5 million, the wife only sought a lump sum of £30,000 and a maintenance per year of £13,000, which, in the grand scheme of things, with £5 million, seems pretty minimal and reasonable at first glance. But the court said no to the wife. The court said that his need was so considerable that it would not be right for the court to impose any lump sum of financial commitment onto the husband. Singer Justice went on to say that their financial positions, while so different, the husband needed much more of the monies, otherwise that would threaten his stability. I think it's important to note in this case, the wife did already have stable accommodation, and the court still did say that the CMS was still needed to be paid. But at first glance, that seems a very harsh analysis from the court, especially considering there are needs. There was a child in this case, and the child was primarily being cared for, well, all being cared for by the wife. But that is one example of how the court has viewed personal injury awards. In the case of A&A, this is an interesting case where the husband had committed a serious assault on the wife that had caused her ongoing psychological consequences. And the judge reflected that as part of the judgment at first instance. That was appealed by the husband. And the main point from this is from Justice Thorpe, as he was then, that the court actually needed to consider that the wife's potential claim for criminal injuries compensation on the basis of, yes, he's caused injuries to her, but she may benefit from a source of income or some sort of award from it. And the judge in that case thought the court hadn't considered that properly. It's very controversial given the fact the husband was the one who caused the injuries to the wife. But that was what the court decided. I will say there are other cases which countered that view, but also it's a 1995 case. There's an argument that things have changed, certainly in terms of development since then, and whether or not that authority would survive the modern age, I'm not too sure about. But another interesting case. The case of Mansfield. This is a very important case, actually, and a very helpful case that came from the Court of Appeal. The husband received 500 grand before meeting the wife. He bought two homes, one for an investment property, and one that was specially adapted to meet his needs. It's important that the husband accepts in this case that it was a mingled asset. And again, the mingling is important perhaps for how the court went on to then divide the assets. So out of the 500 grand or so, maybe slightly more, but the judge of first instance gave the wife 285,000, and the husband got 320,000. The husband did seek a measure order, but that was refused by the courts. The husband appealed, and whilst Lord Justice Thorpe in this case thought it was a slightly too high of award to the wife, given where the capital has come from in terms of personal injury award, he did not interfere with the trial judge's analysis. He thought it met needs and left it as that. But he did come to the conclusion that a measure order was right, and he thought it was the perfect solution in the case where it can meet needs in the interim, but also that at the point in which the measure order no longer is required in terms of often when a child turns 18 or 16, that it's right that the house can be sold and there can be a departure in equality in relation to the capital, as the court done in this case. So the court did make a measure order where there was a need to ensure that the primary needs of the wife and the child can be met. But then upon the child's 18th birthday, there would be an avenue for the husband to receive slightly higher capital in recognising his capital award. So that's an interesting case in relation to measure orders. In relation to Waggatt, I won't go into the details of it, save to say that earning capacity is not a matrimonial asset to which sharing principle applies. And if needs can be met via the proposed compensation scheme, it can preclude a claim to the other party's compensation payments and any future financial remedies claim. So that's just something to bear in mind. In relation to the case of AZ and BZ, the wife had cancer prior to the marriage, but the professionals failed to spot that the cancer had reoccurred and during the marriage, and she was awarded £550,000 by way of damages. Monies were mingled into the marriage. She was the only asset left was really one property in Spain worth 195,000. the husband was in poor health and had a number of difficulties. Interestingly, the judge at first instance made an award which was 99% in wife's favour. Somewhat unsurprisingly, the husband appealed that case, and Judge Vincent, who dealt with the appeal, made the point that far too much emphasis was put on wife's needs, and actually reflected the fact that the wife had, and in this case, the wife had spent significant amounts of money on the marriage, and had in reality bought luxury items and cars, and hadn't prioritized her own needs on the case that she needed the money, for example, because of the personal injury award. So that was an interesting case about ensuring that if you do have needs and you say that it's because of the personal injury award you rewarded that, you must spend your money appropriately. So I think in this case she spent over £70,000 since separation just on day-to-day items, and hadn't spent money on her savings. So that's something to bear in mind. And in that case, the court awarded a 60-40 split in wife's favour. So still recognising the importance of the wife's contributions in terms of the personal injury award, but also reflecting needs and the fact that the award was mingled. It also reiterated that Wagstaff makes clear that the awards of damages is not to be regarded as a special contribution. And I think that's an easy mistake to fall into when we are writing offer letters, but it's not a special contribution by one party of the marriage. Just finishing up, so BC and SC. This was the first case which involved an insurance policy from an award of damages, and how that would be or personal injury and how that would be dealt with. But the court agreed that it would be the same principles of Wagstaff. So if you have a case where there's insurance policies, the principles from Wagstaff apply. And in that case, I think the husband was only 47 and felt that in that case, the court had to ring fence the award of 1.4 million on the basis that was the future income he needed, given he was only 47. The last case I quote is or include is V&V. This is the case really, which is about PI awards, but really about the importance of disability needs and how the court treats that. So in this case, the husband has really significant disabilities to the extent where he received £103,000 from insurance policy. And that was used to buy a house for the marriage. That had a number of adaptations. But in this case, the wife got very little to near nothing from that, despite having the child. And that was because the disability needs were so significant, it essentially overrode the needs of the wife and the child, albeit the court did reiterate the principle of a measure order in this case. So where there are significant needs, the principle of measure orders are clearly an important tool. How this case actually provided fairness to the wife and the child is beyond me somewhat, but it's an important case, especially if you are arguing that your client has got significant disabilities. And I've included more about this case within the handout. So that's a summary of the main cases and the main case law. And as you will see, there are not many. And the handout breaks it down in more detail. But that's all well and good. It's then knowing how we seek to preserve or ring fence any personal injury awards. We know that it's not automatic that you can do that, but what can you do, or what can your client do to try and help you achieve that outcome? Now, obviously, the most obvious one is a pre- and post-nuptial agreements. That is, if you live in an ideal world and the client comes to you with the award being provided and they want advice. Clearly, that makes sense. We know from Lord Phillips in 2010 that the court should generally give effect to a nuptial agreement if it's freely entered into by each party with the full appreciation of its implications. So that's the obvious point. The other point may be a personal injury trust, That doesn't prevent the award being available as a resource to meet someone's needs, but it does show a clear intention by one party that they do not intend to mingle that money. It's separate. And there's a way in which potentially how savvy the trust is to receive an interim payment or interim income from that to meet needs. Having said that, personal injury award trusts are complex areas of law. Any client who's interested in that should seek specialist advice from counsel or from a solicitor who specialises in that, so that can be prepared. Separation of assets and investments, etc. I'll come on to this now. All we can really do is probably advise clients about Standish and the key principles that come from Standish in terms of how mingling is treated, how matrimonialization is treated. And we've got to be very careful that we don't overstep our boundary in terms of ways in which they can be savvy with their money or invest it in a certain way. But we can advise them as to what the law says or what the possibilities of the award being treated. What they then do is a matter for them. Speaking to a financial advisor, that is a matter for them. We can advise them on the law, but we've got to be very careful that we do not advise them to how they invest their money, for example. I had a recent case where I was to the wife, but the husband was an ex-professional golfer. Prior to the marriage, he invested his money into a friend's property and as a charge on the property. And what that meant was, one, it was not mingled, but two, it was a clever way in which his money was protected by it being deemed unreleasable assets or immediate unreleasable assets. And it worked quite favourably for him in financial remedy proceedings. So that's one way in which I have seen people do this. We can't advise them to do this, but save for advise them to seek to tell them what the law says, and they can make decisions that they wish. Obviously, early advice is imperative. Ideally, they will come to you once the award's given, but we do live in a reality where that often doesn't happen. And we get in situations where they only come to us once the marriage has broken down and there's a claim potentially for it. So if we presume that there is no pre or post-nuptial agreements, there is no personal injury trust, the question is then how do we go about settling the case in the interest of our clients? This very much depends on which way you are batting in relation to this argument. So if you are for the individual who received the damages, you will need a lot more detail and information. You want to know data from the personal injury solicitor, how have damages been awarded and broken down. It's important to note that if the case settles at a certain stage, it may be that there's actually not a clear breakdown as to how the damages were awarded. And that's something the client has to be careful of, because it's important if we can see if it was damages for future need or was it because of more special damages, for example. Of course, the damages awarded for future needs are going to be more arguable in relation to you saying they should be ring-fenced because they are to meet a set purpose. So it's important that we can get a breakdown, if possible, from the personal injury solicitor to know how the damages have been split and why. Was it mainly for pain and suffering? Was it because of loss of income? These are all factors that you need to find out. The client can obviously provide you with consent to contact the personal injury lawyer, and you will therefore be able to obtain that. In terms of needs, it's sensible to receive evidence as you would in normal cases when there's concerns about needs or disability in a Form E, about from a consultant as to how the needs can be met, how much will things cost, what level of support will they need. So pretty normal in that approach there. You also have to be realistic. You have to advise them as to how much you think the money appears to have been mingled. Of course, if the award comes in early on in the marriage, and it's a lengthy marriage, it's more likely to be mingled. If it's later on and they've done things such as keep it in a distinct bank account, you may be more likely to argue that it has been kept distinct. So you need to explore that with the clients and potentially advise the client early on. And it is a case where you think a measure or a chargeback is a good idea. I mentioned the two cases, Mansfield and V&V, where the court considered and made that order, but it may be something worth considering. Periodical payments, again, it sounds pretty standard. If there's an argument for future needs, that may be an argument that you need to run. But in a small money case, there needs to be some realistic consideration. If it is the reality that you say there is going to be an invasion of some of the personal injury award, then work out what that should be and how you come to that conclusion. Justify why you come to that view. And you can argue, you can do that and argue it should be ring fenced. So that is, and also work out what the other party actually needs. So if the other party are saying that they need X, Y, and Z, well, why do they need that from the personal injury award? As you would with anything non-matrimonial, the principles in relation to that remain the same, but just have a think about that. If you're for a client who is seeking an interest in the damages, so the other spouse is, it's exactly the same principles. Ideally, you want to be requesting all the same information that you have. One of the points is that you must advise the client as to the different approaches the court may take in relation to personal injury awards and a level of realism and a level of proportionality. They could risk a lot of money and pay a lot of money to seek a result, as many clients will initially want to, but it may be that there's a halfway house that realistically is more proportionate to end the case on. You can be firm with your offers and say that there's no automatic ring fencing. Of course, we know it's going to be fact specific and down to the judge, but you can be bold in your offers. Consider what evidence would support mingling. We've got into that already. And I think this is actually an interesting point. How has the other spouse used the damages to meet their needs? Or has it been spent on the party's marriage? I think of the case where the wife, I think it was Mansfield, where it was 195 she had spent, or that's the only property she had, but out of the £550,000 awarded to her initially, she spent it on the marriage. And actually, it's quite easy to see that the award that she received, did not need to officially meet her housing needs, her future needs. So it's worth looking at that, looking at bank statements, looking at how you can work that all out. Measure and chargeback, I've mentioned that already. And then this is interesting. It may be a situation where there is a delay in the personal injury award actually being paid, or it's still going on, or it hasn't happened yet, but it may do. And there may be some thoughts and some benefits in considering whether you should actually adjourn the application or the capital claim. That's something which a client may not want to do or may want to do. It depends on how big the pot we are talking about. It may be there's some advice that they can obtain as to the likely financial settlement they may receive. But there are some cases on it. And in relation to D&D, a simple summary is, can justice be done if there is an adjournment? Is there a real possibility of capital becoming available from a specific source in the near future? So they're the questions that you have to ask. In the case of Kwon and Bray and others, the judge must adjourn the wife's capital claim without a time limit, given the husband would very likely accumulate sufficient sums in the future to enable a clean break. So that's interesting. In the case of AW&AH, Justice Roberts allowed a 7-year adjournment. Older cases seem to suggest it could be no more than 5 years. But from the two more recent cases, it seems very much that presumptional view, is no longer the case. But of course, it has to be proportionate to the case and what sum is likely to be awarded. So that was a whistle-stop tour of personal injury awards, how we can preserve damages and what you do in a situation where you're faced with a personal injury award. I hope that was helpful. Perhaps we'll move straight on to Julia's tour and then we'll do questions at the end. Is that all right with you, Julia? Or you're still on mute?
Hi, everybody. Hopefully you can see my screen now. Richard, will you let me know if that's right?
That's right.
Great stuff. I want to start really with a question that every one of you will sort of recognise the shape of, even if the numbers involved are, in our cases, usually a lot smaller than today's case. Okay, so you've got your order, and maybe it took a difficult negotiation to get to a consent order, or maybe you went all the way to a final hearing. And either way, you've got the order, it's done, it's sealed, and everyone's moved on. And then months or years later, you find out, or one of your clients finds out, that there was actually a great deal more money than anyone thought. Maybe a former spouse has mentioned something that they shouldn't. Maybe a nominee's name turns up somewhere it's got no business being. Or maybe, as happened here in the case of Gohill, the other side's ended up in the Crown Court as a defendant, and a confiscation order's landed with a figure on it that nobody in the family proceedings ever saw coming. So today, I want to look at what you actually do in that scenario. Well, there isn't one answer, there are several, and they don't overlap as neatly as you'd like. So strip away the procedure for a moment, and there's really three different stories the law tells about why an order stops being final. Set aside is for when the order was wrong from the moment it was made, because someone lied or hid something material. And thwait is for when the order was right, but there was never actually the carrying out into effect, so it's sitting there unperformed. And then barda, well, that's for when the order was right and was carried out, but something's happened shortly afterwards that no one could have foreseen, and it's pulled the rug out from under the whole thing. So it's the same starting problem and three completely different routes in, with different tests and different time limits and very different odds of success. Now, so you don't have to take notes throughout my presentation, can I assure you that the actual session is being recorded, and also that you will be able to get a copy of my handout, which I've put a lot of detail into, by emailing Gizzy at events@parklaneploudon.co.uk. And if you forget that email address, you can always contact me with individual comments or questions. So, same starting point and three completely different routes in, with different tests and different time limits, and actually very different odds of success. And Gohill is probably the most extreme version of that problem that the law's ever had to grapple with, because she got a modest £270,000 by way of a consent order, half of the matrimonial assets. But she had a husband who turned out to be sitting on assets running into tens of millions of pounds. And we've got here a wife who spent 23 years and three separate court systems finding out just how much more there really was. So I'm going to use Gohill as the spine of my talk today. But the real question I want you leaving with isn't what happened to the Gohills, it's what you will actually do on a Monday morning if your client walks in with these problems. Mrs. Gohill didn't accept the consent order. She went and she qualified as a solicitor herself. She didn't practice, but she went to law school and got qualified. And she did that so that she could fight it herself. And those of you that chuckled privately and sent me messages after my posting on LinkedIn will recognise those of us who grew up with Legally Blonde or admired Elle Wood's character will see that there's more than a little Elle Woods about what Mrs. Gohill did, isn't there? Because the person everyone underestimated turned out to be the one who understood her case best. And by the time that Mrs. Gohill reached the Supreme Court, she also had a formidable team acting for her, largely pro bono. She had, I think, Sally Harrison, she had Ros Beaver from Irwin Mitchell, and Sam Hillis backing her up at that point. But she had led the march, and she had not just the profession rallying behind her at that time, once the scale of the injustice became clear, but it had all started with her representing herself and refusing to be told that the story was over. And I think that's worth honouring for a moment before we sort of get into the forensic detail. So then what followed? I'll talk you through what happened to the husband. He was convicted of money laundering and forgery and given a 10-year prison sentence. He was a solicitor and he was struck off the roll. And he was made subject to a confiscation order of just over £28 million. So when the family court finally sat, Mr. Justice Williams found nearly £28 million of realisable assets. And out of all of that, the wife ultimately recovered about 69.5% of the identifiable marital pool. Hold on to that figure, because a big part of today is building up on how on earth the judge arrived at that figure. So he arrived at that figure, I'll come back to it, by looking at what of the assets wasn't tainted. Okay, so let's move on to the framework, because here's the framework I want you to take away. And it's really, as I say, the spine of everything today. When a client comes to you saying there's more money than we thought, the instinct might be to immediately reach out for a remedy, but you can't do that. You've got to diagnose the symptom first. And I suggest there are 3 questions and that they each point you in different routes. Firstly, was the order wrong when it was made? Did somebody lie or hide something? And if so, you're looking at a set aside, which is what happened in Gow Hill. Second, was the order never actually carried out? Is it still sitting there, unperformed? Well, if that's the case, you might be in Thwaite territory. And third, was the order right and carried out, but then overtaken by something that nobody could have seen coming? Well, that's a Barder event. So wrong, unfinished, or overtaken. That's my triage. There's also, of course, the ordinary appeal route sitting alongside all 3, in time or out of time, and it can overlap. Haven't got time to go into that today, I've got half an hour. But those 3 questions are how you work out quickly which door you're going through. And I'm going to come back to this exact picture at the very end. And as we go through each route, this diagram will, in theory, light up one branch at a time. So, why set aside and not Thwaite or Barder? Let's apply that to Gow Hill straight away, because it tells you why this became a set aside case and not one of the other 2. The tell is right there in the order itself. Recital 14 recorded the wife's belief, which husband disputed at the time, that the husband hadn't given full and frank disclosure. Think about that. The order itself, in its own recitals, flags that disclosure might not have been complete. And that's about as clear a warning sign as you'll ever see that an order may be vulnerable later. And it's worth telling your clients to watch for language like that in their own consent orders, if the other side have put it in. Now, could this have been a Thwaite case? Well, not really. It's right that part of the lump sum was still unpaid by the husband in 2007, and he had over 100,000 still owing to the wife. But an unpaid instalment isn't the same problem as a concealed asset base, and so Thwaite was never really built to fix the latter. And Barder, well, no, Barder needs a new event shortly after the order, and you simply can't stretch it across the years, let alone as here, decades that this case ran. So set aside it is. All right, so my next diagram, let me walk you very quickly along this chronology, because the timeline itself sets the story. And in 2007, the wife applies to set the order aside, alleging non-disclosure. And tellingly, part of her evidence came from the husband's own father, who had gone into Team Wife by then. The father's father had registered in his own name some pretty extraordinary supercars. that he'd never bought, the husband had bought, for example. In 2008, the husband gets charged by the police, and so things stall. And in September 2012, Moylan J sets aside part of the 2004 order. And in the very same month, the husband is convicted of fraud and struck off from being a solicitor. Well, then it seesaws because in 2014, the Court of Appeal allowed the husband's appeal against the set-aside. Then in October 2015, the Supreme Court allows the wife's appeal and restores Mr. Justice Moylan's order. And that, by the way, is the very same day as the case of Sharland and Sharland, which some of you will be familiar with. They were both heard at the same time on the same day. And I do remember at the time, both Mrs. Sharland and Mrs. Gohill standing on the steps of the RCJ, delighted that they had won their cases. But in Gohill, confiscation proceedings then ran from 2020 to 2023. And the final hearing before Mr. Justice Williams sat over 4 weeks in the spring of 2025. Now, the judgment came in June 2025, but publication was held up pending a further appeal from the husband, which is why we're talking about the 2025 judgment that only surfaced this year in 2026. 23 years later, 3 court systems and 1 order. So that's also where Family Procedure Rule 9.9a comes from. And it's worth pausing on why 2015 mattered so much, because Sharland and Gohill together changed the test. Before that, there was really real doubt about how high the bar was for reopening an order for non-disclosure. And what the Supreme Court settled is this, that the threshold is materiality. And if the non-disclosure was intentional, it's presumed to be material, and the burden flips to the person who concealed to show it wouldn't have made a difference. And once you're over that line, the court doesn't have to first reconstruct some hypothetical fair order. Fraud, as they put it, unravels everything. And that's also where Family Procedure Rules 9.9a comes from. I know the Family Procedure Rules are 2010, but Rule 9.9a didn't come in until 2016. And it's the procedural home for these applications. And that rule was brought in directly in response to these 2 cases. And that judgment got Mrs. Gohill the right to a rehearing back in 2015. But it then took another decade to work out what that rehearing should actually look like. And that's the rest of the story. Finding the money. So that's the history and the law that got us here. And I'm going to shift gears from what happened to how you actually prove it. And this is the forensic part of the case, finding the money. Now, this diagram looks complicated, and that's rather the point. What you're looking at is the shape of the problem that the court had to unpick. And if you go into the judgment, it runs to 303 pages. I don't think I've read a longer judgment, and the last sort of 80 or so pages are chronology and sort of setting things up, so it explains the rest of it. But the whole forensic exercise across 23 years by Mrs. Gohill was to establish, structure by structure, in common with the police and the CPS, that assets held in the names of trusts, companies and family members were in reality beneficially owned by the husband. And it wasn't uniform. Some structures were found to be shared with a third party. Others were found to be the proceeds of crime held jointly with others. And so it was painstaking, asset by asset. And these things surface in the most unexpected ways. So one of the offshore accounts only really came into focus in 2020 when new evidence arrived from the ex-husband of one of the husband's own sisters, describing how the husband had added his sisters as signatories to an account and then quietly removed himself. And that's the texture of these kind of cases. The evidence sort of emerges from the edges. And I want to dwell on one figure in particular because this is the practical lesson most likely to be useful to you. One of the husband's family members, the husband's sister, held paper title to a significant slice of this disputed estate, and she simply never engaged, not at any stage, despite 2 separate court orders, one criminal and one in the family proceedings requiring her to. Now, your instinct might be to say that silence is the problem because we can't prove anything, that a nominee who won't turn up is a dead end. But actually, in this case, it shows that it's sometimes the opposite, because once you've got a debarring order in place with a hard deadline, that silence becomes, it stops being a stalling tactic and it becomes evidence in itself, because the court's entitled to draw an adverse inference, as it did in Gohill. So the tactical takeaway is simple. Don't let a silent nominee run down the clock. Debar them on a deadline, and their non-engagement starts working for you, for your client, and not against you. Okay, so now we hit the really interesting doctrinal collision where 2 jurisdictions meet. You've got a criminal court that's made findings about benefit from crime and a confiscation order for a huge sum. And you've got a family court being asked to divide assets. And the temptation is to assume that the criminal findings just carry straight across, but they don't. The family court has to make its own findings, and it does so on the balance of probabilities. And it gives proper weight to the quality of the criminal court's reasoning, of course, but the statutory assumptions that drive a confiscation order don't simply transplant. And running underneath all of it is a firm public policy line. Tainted assets, the proceeds of crime, should ordinarily not be handed out by the family court at all. And one detail worth noting, in the head note to this case, which even the head note takes 2 pages, because the CPS actually were one of the interveners in the family proceedings, and their barristers cross-examined the husband directly about where the money came from. So this wasn't the family court guessing at the criminal picture. This was one where the 2 systems were genuinely talking to each other. I've added in my notes some other cases where that's happened because it's unusual, but it's not the only case. Right, this is the slide for me to slow down for, because this is where the 69.5% actually comes from. So the judge starts with the husband's realisable assets, which is also the confiscation figure, just under £28 million. So I'll treat that as being the universe. And then the judge asks, which of those assets are untainted and traced back to the marriage? And the short answer is about £6.6 million, which is just under 24% of the total. And then you add back the £170,000 the wife had already received under the original 2004 order. So that gives you just over 6.8 million. And within the case, the judge identified the total identified marital pool as about £9.8 million. The judge is refreshingly honest in the judgment and says that the figures are broad brush. Some of the valuations were years out of date, and he says in terms that he prefers finality over some spurious arithmetical precision, which I think is rather a relief to hear a judge say out loud. So, of that 9 million and something, how do we get from that pool to the final award? Well, this is where it's genuinely interesting, because it wasn't a simple 50-50 case. The judge describes the whole exercise as, in his words, very much an art rather than a science, and he starts from the sharing principle. And then he adjusts upwards for 2 reasons. Firstly, conduct. And he places the husband's dishonesty, as it was in this case, at the very highest end of the scale. And for those of us that get a bit bored from saying, actually, the conduct's not going to be a good point, it's not going to make any difference. Of course it does when it impacts on the size of the matrimonial pot. And this is a good example of that. And second, the uplift wasn't just because of that. There was also compensation. And the compensation here realistically was for the impact of a 23-year fight on the wife's part and the impact of that on her life and on her own earning capacity. Now, on conduct and compensation alone, he says he could justifiably given her 75 or even 80%, arguably up to 100. But, and this is a crucial point, he caps it at the untainted recoverable assets, because to award her more would be to make an order against the proceeds of crime, and he won't do that. So she essentially receives 100% of the clean recoverable marital money. And that money is what would have been in existence prior to the commencement of the husband's criminal activity. About £6.8 million versus, as I said, her original award of £270,000. And the lesson for our clients is a useful corrective, I think. It's not simply the worse his conduct, the bigger the award. Recoverability still bites. You can only share what can actually be reached. So here we are, set aside for non-disclosure and a framework. This is a route one, set aside for when the order was wrong and when it was made. Think of it in two stages. Firstly, have you crossed the materiality threshold in Charland and Gohill? Was there fraud or material non-disclosure? And second, does the application also satisfy the Tibbles limbs, which the Court of Appeal applied to family orders in Norman and Norman? That is, a material change of circumstances or facts that were misstated or a manifest mistake by the judge, and crucially, brought promptly. There's a few cases worth knowing here, again, which I've put in the handout. Norman itself tells you that repeat attempts on facts you already had will fail, and that a change in the law isn't a material fact. Finality matters. Rucroft tells you, strikingly, that set aside can even run against the estate of the party who's died. And there's a real cost warning lurking in this area. In one case, the husband won his set aside and still recovered only half of his costs because his own conduct in the litigation couldn't go uncriticised. So winning isn't a blank cheque, and all my citations are in your handout. So the lie scales the remedy, and this is an idea I want you to take away. The remedy is not a one-size-fits-all. The scale of the reopening tracks the size of the lie. So at one end, you've got Kingdon, and there the husband had concealed a single shareholding. I think his initial shareholding was for £200,000, which he should have declared, but he sold it for 1.6 million. And everything else in the order was sound. So the court didn't tear the whole thing up. It made a proportionate top-up for half of what he had obtained when he sold the shares for 1.6 million. One lie and one discrete fix. But then at the other end of the spectrum, you've got Gohill. And here the fraud ran through absolutely everything. You couldn't trust any part of the original picture. So Williams J didn't just tinker. He reconstructed the entire marital pool from scratch. And on that broad brush basis that we talked about. So when a client comes to you with a discovered single non-disclosure, I suppose that's the question to ask. Is it a single rotten brick? Or is the whole foundation rotten? Because that tells you whether you're asking for a top-up or a complete rebuild. So, the Thwaite jurisdiction. And this is a bit controversial at the moment for reasons that I'm going to go into. This is route 2. And this is where the order was right, but it was never actually carried out. Now, the core idea is straightforward. Where an order is still executory, still unperformed, the underlying application is in a sense still alive, and the court retains the power to vary how it's implemented. And the attraction's obvious. It can be faster and cheaper than pleading fraud because you don't have to prove anything about the other side's conduct. You just have to show the order hasn't been carried into effect. So, a good practical triage question at that first meeting is simply, has the order been implemented? Because if it hasn't, Thwaite might be a quicker door, although I'm going to hesitate at that point, because I want to flag this clearly before we go on. I've called this the conventional account for a reason. And if you look in the Red Book, it will tell you that you can go ahead under the Thwaite jurisdiction. But right now, this jurisdiction is being fought over, really. at the highest levels of my colleagues at the specialist bar, and that's what I'm going to turn to next. And this, I think, is probably one of the liveliest arguments in our field, if you're into that kind of thing, and it's genuinely unresolved. So I'm going to give you both sides. And the best way, I think, to hold it in your head is the sort of shield versus sword argument, because everyone agrees that Thwaite can be a shield. And what I mean by a shield is that a court can refuse to enforce an unperformed order where enforcing it would now be unfair. So the sword is protecting, sorry, the shield is protecting. The fight is over whether it's also a sword, so it can be used proactively, whether the court can go further and actively rewrite the order into a different one. And the arguments being conducted this month and last month through the Financial Remedies Journal. And on one side, Sir Nicholas Mostyn says the sword simply doesn't exist. And his killer point is this: the order in Barda was itself executory. And the House of Lords knew that. They knew about Thwaite because Thwaite is from before Barda, and they didn't use it. So a softer route can't exist, and inventing one drives the coach and horses through a statutory scheme that deliberately makes these orders non-variable. But on the other hand, a run of judges have applied it, and their worry is a practical one. It's what you might call the cheats charter point, because if a spouse can deliberately sabotage an unperformed order by raising the Thwaite jurisdiction, and the conduct is too foreseeable to be a Barda event, then surely the court must have some remedy. Otherwise, you reward the saboteur. Well, I think everyone agrees that this is heading to the Court of Appeals. The practical message for now is that if you're running a Thwaite argument, plead it in the alternative and warn your client that there's a real jurisdictional risk on top of the merits. I've put a link to both articles from the Financial Remedies Journal. One's from June and one's from July of this year. Nicholas Allen KC on the one hand and Nicholas Mostyn on the other. So I'm going to turn to look at Barda events, because this is a different animal entirely. Route 3, and it's for where the order was right when it was made and was carried out, but there's been a new and unforeseen event that knocks away the very basis upon which it rested. And because that's such a powerful thing to unpick an order that was perfectly sound, the bar is set deliberately high. 4 conditions, and they're cumulative. A new event, invalidating the fundamental assumption occurring within a short time. A prompt application, and no unfairness to a third party who's relied on the order. 2 quick cases will show you the line. In Meyerson, a husband's award was built around shares, and his shares then collapsed in the 2008 crash. Not a Barda event, the court found. Market movement's an ordinary risk of owning shares, and as the saying goes, a share price falling isn't a Barda event, it's just the weather. But in Critchell, shortly after the order, the husband unexpectedly inherited a house on his father's death, which completely transformed his position in the financial landscape. So that was a Barda event, genuinely unforeseeable and acted on promptly. And here's the distinction I want you to hold on to, because it's easy to blur. Non-disclosure means the order was wrong when it was made, and there's no fixed time limit. Gohill ran for decades. Barda means the order was right and was then overtaken, and you have to move quickly, within weeks or months. Different triggers, different tests, and very different clocks. So, let me bring this back to your desk, because this is the slide to take a photo of. When the call comes in, preserve first. Get your section 37 freezing and preservation orders ready and in early, and then renew them as structures come to light. Then diagnosis. Was the order wrong, unfinished, or overtaken? Pick the right remedy. And this is the bit that ties everything together that we've just done. Debar your silent nominees on a hard deadline. Understand that the criminal and family findings don't simply transplant. And match the remedies to the fraud. A top-up for a single lie, or a rebuild for a wholesale concealment. And finally, manage expectations, honestly, on time, cost and recoverability. Gohill took 23 years, and even the strongest conduct case in the world is still bounded by what can actually be recovered. And so we come back to exactly where we started, the same 3 questions, because here's the reassuring part. You don't need to carry every case and every citation around in your head. You need to ask the 3 questions. Was the order wrong when it was made? Was it never carried out? Or was it overtaken by something nobody saw coming? Diagnose the symptoms and the route follows. So if you take 3 things away from today, let them be these. First, finality is not the same as certainty. A sealed order can still be reopened, and Gohill is the proof that that can happen decades later. Secondly, diagnose before you reach for a remedy. Wrong, unfinished, or overtaken. 3 symptoms, 3 routes. And third, match the remedy to the wrong. The scale of the reopening tracks the scale of the lie, and recoverability sets the ceiling on all of it. Now, that, in a case that took 23 years, is what I'd want on a single page. I've set out the 3 things to remember about Gohill. Again, that's in your notes. So, with that, we can open this up by way of email to me. I'm very happy to take questions on the case, in any of the 3 routes, or about how you'd handle something similar in your own practice. And ask yourself this: where in your own caseload might a Thwaite application be quicker than a set-aside? If anyone's run a BARDA argument recently successfully, did it survive the Meyerson-style scrutiny of foreseeability? And how would you approach a nominee that wouldn't engage? And what would you tell a client about timescale and cost expectations after hearing this? Well, all of those topics, all of those are questions. I'm just going to go to the chat. I don't know if anybody's put any questions on the chat, but thank you very much for attending. Myself and Richard will be very happy to take questions by way of email. Lovely that you all attended. Not to see you all because I can't see you, but I'm going to say goodbye to you all, and I hope you have a very enjoyable rest of day. So it's goodbye from me and goodbye from Richard. Thank you. Bye-bye.